Hello and welcome to this edition of Inside Judicial Watch. I'm your host, Jerry Dunleavy. Over the past couple of weeks, Judicial Watch has achieved some impressive victories in the battle for government transparency. Our Freedom of Information Act lawsuits resulted in the Department of Justice being forced to release FISA applications and FISA warrants related to Carter Page, resulted in the FBI being forced to release emails from biased FBI agent Peter Strzok, also resulted in the FBI being forced to release information detailing some of its relationship with dossier author Christopher Steele. And a federal court also ordered the Department of Justice to preserve any records on the personal email accounts for former FBI Director James Comey. So a lot of big wins there, and here to discuss all of those wins is Judicial Watch President Tom Fitton. So thank you very much for joining me today,
Well,
Tom.
thanks for letting me come on the program today.
Absolutely. glad to have you on. So if it's okay with you, Tom, I'd actually like to start with a discussion about the FISA application and FISA warrants that we got the Department of Justice to release. As our viewers can see, it's hundreds of pages of pretty heavily redacted documents. But there is some information in there that was important. It's still a big deal. So if you could walk our viewers through kind of why we were so concerned about the FISA issue and why getting these documents released matters so much.
Well, we began asking for them a year ago, and we had to sue for them. And Devin Nunez, who's head of the Intelligence Committee, who looked at them because he's head of the Intelligence Committee, he could look at them because typically they're classified and secret, said that the Clinton DNC dossier was the center of these FISA warrants. So you had this campaign-funded anti-Trump dossier being used to justify secret spying on the Trump team. And Nunez alleged that the courts weren't told about this. And there were other material omissions that the courts may have wanted to consider, of facts that the courts may have wanted to consider, but they weren't told about it. So, you're looking through these applications, and this is the first time applications, FISA secret applications, have been released to the public, and parts of them are declassified. And the only reason they're declassified and have been released because President Trump made the decision earlier this year to declassify information about the use of the Clinton DNC dossier to target the Trump team. And so the documents are really outrageous because they show that the Clinton DNC dossier, well, the Nunez Memo was correct, but they confirm the Clinton DNC dossier was used in a central focus of the warrant. As Andrew McCabe testified, I think, to Congress, he said no dossier, no warrants. And indeed, these documents confirm that. And then the document references the dossier 3 or 4 times in disguised ways. And they tell the court or pretend to the court that it's different information. So they reference the Clinton DNC dossier, the author, Christopher Steele, who was an agent of Fusion GPS, who was an agent of the Clinton DNC arm. But then they reference news articles based on leaks of the Steele dossier. Then they reference congressional concerns based on leaks of the Steele dossier. And then they reference State Department information about Carter Page, who was the target of this warrantless, this secret spying, I should say. It's not warrantless. And they don't mention that was tied to the Steele dossier or elements of it. So you have the warrant reference one piece of information 3 or 4 times as separate pieces of information. I mean, that's fundamentally dishonest. It's like if I tell you I've heard something, and you say, oh yeah, who from who? And I say, well, from me, myself, and I, 3 people. And another way of thinking about it, it's a self-flicking ice cream cone. It's a circular feedback loop that was disguised in seeking the awful power to spy on American citizens based on the allegation that they were foreign agents. And they didn't have anything really to point to other than this dossier. And they pretended to the court otherwise. And who's responsible for this? We have the people who signed it are in the warrants. James Comey, Sally Yates, the Obama holdover, Andrew McCabe, Dana Puente, who is a Obama holdover now, the general counsel of the FBI, and Rod Rosenstein. And Rosenstein signed off on one of these warrants in June of last year during the Mueller operation. So Mr. Mueller has to answer for these abusive warrants as well. And the president's taken notice of this. He highlighted these records were uncovered to Judicial Watch, and now it's up to him to declassify the rest of it, because what members of Congress like Nunez have said, who have seen this, they said, well, if you think the DNC dossier was bad, the Clinton DNC dossier was bad, there's even worse stuff in this material that hasn't been released yet. So the president needs to intervene and release this information.
And because you referenced that the Nunez memo being released helped with allowing this information to be released, and now that this information is
right.
out,
The president declassified the Nunez memo that referenced this, so they really couldn't withhold all of this from us anymore. So eventually, as a result of our lawsuit, we were able to get these FISA warrant applications, and an incredible accomplishment.
And it's your hope now that the president goes ahead and releases more.
Yes, and there's not only here, but there's all sorts of other things he could be declassifying too. But this is a good example of why the president needs to intervene, because Rod Rosenstein doesn't want to look bad. He's not going to authorize the declassification if he can help it. The general counsel of the FBI, who also signed off on this, he's conflicted out. The president's the only one who can really do it, in my view, or ought to be able to do it, because I don't really trust the FBI and the DOJ to expose their own corruption.
Yeah. Now, related to this, Judicial Watch ended up filing a motion with the Foreign Intelligence Surveillance Court itself, asking for any hearing transcripts related to these, the FISA process here, related to Carter Page. Can you walk us through a little bit what we're trying to get at there?
Well, this is interesting as well, because Devin Nunez asked the head of the FISA court at the time, can you release the transcripts? Because we have these warrants, these shady warrants. Well, was there a discussion about what was in them? Did they tell the court what was in them? So are there transcripts of any discussions with the court? Did they have a formal transcript developed? And the court said, well, look, we told the Justice Department we don't object to them releasing any transcripts. So Judicial Watch asked for the transcripts from the Justice Department. The Justice Department came back to us and said, well, look, we can't tell you if there are transcripts about General Flynn, because we asked about that as well, because we suspect there were FISA warrants on General Flynn, a top advisor to the president-elect, the campaign, and obviously the president later. But they said the president did declassify material about Carter Page, and we can tell you whether or not that exists, and we don't have the transcripts. So what do we do next? Well, we go back to the court and say the Justice Department doesn't have the transcripts. If you have them, please release them. Now, it's going to be interesting to see what the answer is. Are they not going to answer us at all? Or are they going to give us the transcripts? Or are they going to tell us, again, there's no transcripts? And if there are no transcripts, it really undermines the way this whole process is working. Because to have confidence that this process is working well and right, you want the courts to be asking questions. What's going on here? This is not an insignificant issue. We all know you're targeting the Trump campaign. You look at the documents, it's pretty clear you want to go after the Trump campaign. The basis of this is they were trying to work through the Trump campaign to do bad things, the Russians were. And if there are no transcripts, that means there were really no hearings and substantive discussions, and it was a rubber stamp.
And what the thing that you're trying to point out here and that we're trying to get at is that there's at these FISA hearings, there's no one there sort of for the defense. It's called ex parte, it's non-adversarial, so this information is being presented to the court, and the hope that you're getting at, the hope is that the court is at least asking some questions, probing some of this, and if no hearing transcripts exist, that means maybe that didn't happen.
My understanding is transcripts are only taken about half the time these warrants are sought. So 4 different courts approved, one court approved the initial application, and then they renewed the application 3 more times, and 3 different courts approved those renewals. I'm sure there's not one transcript among any of them, or from any of these warrant applications, then something's not working with the FISA process, that's for sure.
Yeah. Let's move forward to a little bit of a different topic. Judicial Watch, through a few of our different FOIA lawsuits, also got the Department of Justice to release some information about Peter Strzok that we didn't know before. Peter Strzok, of course, the biased, as we know, FBI agent. Talk to us a little bit about what we were able to find out, because this information is coming out in little drips and drabs. Talk with us about what we were able to learn about Peter Strzok and his relationship with the Mueller investigation.
Well, we know we have several lawsuits about Peter Strzok, and he's the infamous FBI official who hated Donald Trump, loved Hillary Clinton, ran the Hillary Clinton investigation. Surprise, surprise, that worked out well for Hillary, and was running the anti-Trump Russia investigation. We all know how that worked out. It resulted in a special counsel, and as we pointed out earlier, this illicit spying and targeting of the Trump team. So we asked, so what happened is Mueller was running Clinton, Trump, Russia. Eventually Mueller was appointed, and Strzok as the number 2 counterintelligence official, the lead FBI agent on these cases. He was a senior guy. He was not just a junior FBI agent. Moved over to work for Mueller. And eventually these text messages where he talked about wanting to stop Donald Trump, wanting to having an insurance policy in case he won, those text messages were uncovered by the IG, the Inspector General of the Justice Department, I guess last year. And so he was removed by Mueller. Mueller didn't tell anyone about that until 4 months later. We found out through Congress, after the Justice Department finally admitted really what was up. So we had asked questions about his appointment to and removal from the Mueller operation. And so in response to that, we got these emails from Mr. Strzok. And Mr. Strzok was very much concerned about his ability to retain his high-level security clearances. And he had more, I think it's fair to say he had better than average security clearances, and that would have made sense given his position as the number 2 counterintelligence official in the FBI. And one of the things he knew was very concerning and problematic potentially his keeping was his ability to declassify information. Because just think about this. He had these special authorities because he was the number 2 intelligence official. Well, he no longer was, so it wasn't like he could just take those authorities willy-nilly as he was running an investigation for Mr. Mueller. He needed to have a special dispensation. They needed to create a whole new position for him, a special floating directorship of some type, assistant directorship, I think it's fair to say. And so he asked for it, and he got it. Now, why is it he thought it was so necessary to keep declassification authority? I'm not talking about classification authority, I'm talking about declassification authority. Now, Mr. Strzok has a demonstrated record of misconduct, the affair, the illicit text messages. He was removed from Mueller's team. He was walked out of the FBI after more text messages are coming out showing he hated Trump. So should we give him the benefit of the doubt? I don't think so. But I think it's a fair question to ask one way or another. Did he want the declassification authority so he could share dirt from the Trump-Russia investigation, with outsiders, without running afoul of classification, dissemination prohibitions, and insiders? Everyone thinks leaks are always to the outside. Well, you have leaks internally. In order to get it to the outside or to let your friends know, for instance, he was still having this relationship with Lisa Page. So these are the sorts of questions that need to be asked. What was he doing for Mueller? Why did he need these special authorities? Why were they granted to him? And I think Mueller needs to be asked these questions, Strzok needs to be asked more questions, and so should the FBI and DOJ. And again, it's remarkable. It's Judicial Watch that's uncovering this. It's not Congress, it's not the media. We got these warrants, we got these Strzok emails showing this unusual effort to give him special authorities in terms of security clearance and declassification. And this is all just coming rat-a-tat-tat at Judicial Watch over the last 2 weeks. It's incredible.
Yeah. Related to the Mueller investigation, Judicial Watch also was able to uncover information detailing some of the FBI's relationship with Christopher Steele, the author of the dossier there. I took some time trying to read through the 70 or so pages, and again, these are, heavily redacted.
Heavily
and
isn't
blanked
the
out.
word.
I mean, it's like, it's blank.
Well, there are
It's blank,
70
it's redacted,
pages.
It's
2 of the pages have substantive material.
Exactly
the rest
right.
you have to read through between the lines.
so what were we able to learn there about Christopher Steele, and what do we still want to know?
So it's important to remember let's put Christopher Steele back and place him in this greater scheme of things.
Yeah.
So Fusion GPS was hired by a law firm of the Clinton campaign and Democratic National Committee. Fusion GPS went and hired Christopher Steele, who is a foreign spy, or a retired foreign spy, worked for the United Kingdom. And Steele used sources from wherever, including in Russia intelligence sources, to create this shady dossier on then candidate Trump. And this dossier, as we pointed out earlier, was used to justify spying on the Trump team and who knows what else. And we just know about the FISA warrants against Carter Page. We knew there was the Spygate issues where they were sending informants into the Clinton, informants, we don't know yet, into the Trump campaign, all sorts of other things. Maybe there were unmaskings done due to this dossier as well. So Christopher Steele was a central figure here. And as we pointed out, he was the number one source number one in the warrant applications used to justify the extraordinary spying on the Trump team. So these documents show what the FBI was doing in part with Christopher Steele. So there are a few key points. Number one, they had a relationship with him throughout the campaign of at least 2016. On February 2nd, 2016, they admonished him. Now, we don't know why. That's blacked out. Defenders of the FBI say, well, admonishment may have a technical meaning that's not easily discernible to the layman. An admonishment is, hey, these are the rules, follow them. I don't know if that fits in the context, but there's that alternative way of looking at it. But either way, he was admonished, and it says what it says. They also show that in November 1st of 2016, he was deemed not suitable to be used as a confidential human source anymore. Wow. Nevertheless, he was used repeatedly later to justify in at least three renewals of the FISA warrants against Page. And they didn't mention he was not deemed to be used as a confidential human source. They said, well, we had problems with him, but it doesn't necessarily mean his information's bad. Well, I would think the court might want to know if they concluded they can't use him anymore as a source. And why did they conclude that? Because he leaked his relationship with the FBI to the media. And the documents also show they met with him at least 13 times over the course of the campaign. It's not clear about what. And they paid him 11 of those times. Steele was admonished, yet paid for by the FBI, then fired by the FBI. And since these records have come out, these are records the Judicial Watch obtained. Congress didn't have them. If they have them, they haven't released them. The media didn't get them. Judicial Watch got them just last week. It's come out that Bruce Orr, who was a number 4 Justice Department official in the Obama Justice Department, his wife worked for Fusion GPS, again, Christopher Steele's paymaster here. He met with Steele a dozen plus more times after the FBI cut him off. And they laundered Steele's information through Orr into the FBI. So the FBI says, I'm not going to use you as a source anymore because we don't deem you trustworthy. But go ahead, meet with the Justice Department. We'll take your information from them instead. And Bruce Orr, of course, his family was getting paid by the people working with Steele. Same people paying for Steele were paying the Justice Department's wife, Bruce Orr's wife. Incredible stuff, incredible.
And there's also a lot of information to indicate that not only was Steele going through Bruce Orr, to get information in, but that he was perhaps also doing it through perhaps the State Department, perhaps through the Central Intelligence Agency as well. If you want to outline a little bit about what Judicial Watch has found and is trying to do there.
Well, we know that John Brennan leaked dossier information to Senator Harry Reid, then the Democratic minority leader, majority leader, doesn't matter, but the leading Democrat in the Senate, with the hopes that Reid would leak it just before the campaign, which of course Reid dutifully did. Then the State Department was another vehicle for the Clinton gang to launder the information from the Russia dossier into the FBI and DOJ. It's like saying, well, we got intelligence here, the self-licking ice cream cone again. They're hearing it from me, myself, and I. Oh, look, we've got 3 different ways of hearing about this dossier, so it must be true, even though it's the same information being laundered different ways. So we've got lawsuits on that as well. And we found that they were sending Russia-related information to a key Democrat on the Hill as it is. We have more lawsuits to follow up on that, but we're on it. We're certainly on it.
Yeah. The final sort of victory, I would say, that Judicial Watch had over the past week or so is regarding James Comey. Obviously, he was a pretty central figure in a lot of this as well. Like you said, he was signed off on at least one of the FISA application. I believe he signed off on.
Oh, James Comey signed off on everything. I mean, he's responsible for everything the FBI was doing. Look.
Yeah.
This whole Russia investigation, to take a step back, this was run out of D.C. headquarters. I mean, this is a James Comey, Peter Strzok, Andrew McCabe special.
Right.
That's not the way these things are typically handled. The FBI director and top officials at the FBI monitor and supervise investigations done by field offices. Now, they may provide support and expertise out of Washington, but you don't run it from the top directorship and top echelons of the FBI, unless it's so important. Because, well, heck, you're trying to target Donald Trump.
Yeah,
and it's the same thing with Hillary. They were running the Hillary investigation. They were targeting Trump and protecting Hillary, and the only way they could do that was by keeping the Comey gang in charge. And Strzok, McCabe, Lisa Page, Comey, that was the gang.
And those are the people that were making the decisions on both the Clinton investigation and the early stages of the Trump investigation as well. So talk with me a little bit about what we were able to accomplish here with trying to unravel sort of more about Comey's involvement. We've been trying to get the federal court to get the FBI to do some stuff for us.
Right.
So talk with us about that.
We have a lot of document lawsuits. I think we have over 30 Freedom of Information Act lawsuits about this deep state attack on Donald Trump, hundreds of FOIA requests. And obviously, Comey is the central focus of this. And we've sued, along with our friends at the Daily Caller News Foundation, for records about Comey's communications. Did he write memos about other meetings he had? We know he wrote memos allegedly about meetings with President Trump. But did he write memos about meetings with Barack Obama or Bill Clinton or anyone like that? So we were asking questions about that. So this IG report comes out recently from the Justice Department, and the IG report notes, to the glee of Hillary Clinton, who evidently doesn't like Mr. Comey, that Mr. Comey was conducting some government business on his personal email accounts. So we obviously said, well, wait, hold on. We've got FOIA requests, FOIA lawsuits here. Are you searching those personal email accounts? Are you making sure there are no government records there? Are you making sure they're not being deleted? And so in response to our requests there, the FBI sent Comey a letter. And we said, well, can you give us the letter? Our attorneys asked, and we were told no. So not trusting what was going on, we filed a motion for a protective order with the court in this case. And the Justice Department and the FBI objected, as they always do, it seems, to our efforts to ensure transparency and accountability and to make sure documents aren't destroyed. And the court granted our protective order. And so the court said, look, I'm not saying that there's anything wrong going on here or documents are being destroyed, but just to be safe, you should take all reasonable necessary steps to preserve these records. So that was a nice little victory, and it was over the objections of the FBI and DOJ, and the question is what next? Now, the Justice Department and the FBI can tell you they don't want to do anything else. They think the letter was sufficient. Now, I want you to put yourself in the shoes of an everyday American who would be subject to a protective order issued by a federal court, and then the FBI was on the other side. What do you think they would do? Do you think they just send you a letter reminding you there's a protective order out there? Or not even send you a letter telling you there's a protective order? No, they pull a Manafort on you. They probably show up at your home with guns drawn and take your records. But Comey's getting, I'm not saying they need to raid his home, but they need to do something more substantial than what they propose to do in response to this federal court order, which is nothing.
Yeah. So revelations about FISA applications and FISA warrants, revelations about Peter Strzok's special requests about all of the power and authority he wanted to retain when he joined the Mueller investigation, knowing now what we know about him. New details sort of confirming Steele's relationship with the FBI and tying that into his relationship with Bruce Orr, with Fusion GPS, with State, CIA, potentially all of this. And then uncovering things about James Comey and slowly but surely forcing the DOJ and FBI to get serious about, helping us get to the bottom of this. Can you tie all of these sort of loose ends together as we wrap up here and sort of paint a picture of kind of what we know now thanks to Judicial Watch versus what we didn't know just a short period of time ago, and then kind of where we're going to go from
Well,
here?
look, it's thanks to the Judicial Watch. We've got these warrants, the secret spy warrants on the Trump team, new questions being raised about what the anti-Trumper Strzok was doing for Mueller, a federal court order about the documents of James Comey, the disgraced FBI director, and these extraordinary new documents documenting this unbelievable cash-based corrupt relationship with the Clinton dossier, DNC dossier guy, Christopher Steele. And it isn't Congress. Congress is over here that's getting these records. It's Judicial Watch that's getting the records. And so it tells you that Judicial Watch is really in the center of the storm when it comes to holding this government to account, holding the Mueller operation to account, and the DOJ and the FBI to account. And there are members on the Hill who are doing good things like Devin Nunez, I pointed out, and Mark Meadows, and even Chuck Grassley's putting some additional pressure on the Justice Department from the Senate side. But in terms of an independent watchdog, there's no one doing more than Judicial Watch, and no one's doing more successfully than Judicial Watch to get this core information out. This would never have seen the light of day, these various documents we're talking about, but for our pressure. And even when we don't get them and Congress gets them, you can bet it was our pressure that forced them to give them to Congress.
Yeah.
So it's a testament to the supporters of Judicial Watch, because we wouldn't be able to do it without them, the legal acumen of our team. And the most important thing we do, in addition obviously to the investigations and the litigation, is we tell you about it. Because the worst thing in the world the deep state wants, the deep state fears, is being called out. And they fear transparency. And so by educating people about what we're doing, we're really doing the Lord's work.
Yeah, and that's why I so appreciate you coming on today, as the president of our organization, coming on, explaining all of this to our viewers, so that they know what we're up to, because it is really important work. So I really do appreciate having you on today.
Jerry, it's exciting stuff. I mean,
Yeah.
you talk to our colleagues here, but it's amazing because there's no one doing what Judicial Watch is doing.
Oh yeah.
And I don't know what we'd be doing. I don't know where we'd be without us.
Getting to see these.
We're happy to do the
documents,
work, but isn't it
Yeah.
outrageous that Judicial Watch is the only game in town?
It is, and every time that these new documents come in, and we open them up and we it's crazy that we're the ones that are having to find it, that we're the ones that are having to force FISA applications and FISA warrants out, and that we, the interesting thing is that we filed a motion even in a secret court, the Foreign Intelligence Surveillance Court, trying to get some of this information. I mean, it's just we're doing really interesting and unique work. So
well, there's a conspiracy, an illicit one, to take out the President of the United States. It includes abuses of our federal law enforcement agencies, our intelligence agencies, and who knows what else. And we're going to expose it. That's for sure.
So thank you very much, Tom, for being on today, for helping to explain all of that to our viewers. We really do appreciate your insights and your expertise in laying out all of this important information. And if you want to continue to understand what's going on, be sure to follow what Judicial Watch is doing. Follow us on Facebook, follow us on Twitter, follow us on Instagram, subscribe to our YouTube channel so that you know what we're up to and what we're uncovering. And also be sure to follow Tom on Twitter. He has a great Twitter account, great insights, and he's a good person to follow if you want to know what's going on in Washington, D.C. So thank you very much for tuning in today. Until next time, I'm Jerry Dunleavy for Inside Judicial Watch. Thanks for joining us.